Welcome to Thinking Like a Lawyer, with your hosts Ellie Mistal and Joe Patrice, talking about legal news and pop culture, all while thinking like a lawyer, here on Legal Talk Network.
Hello, welcome to another edition of Thinking Like a Lawyer. I'm Joe Patrice from Above the Law. I'm joined by another senior editor from Above the Law, Catherine Rubino.
Indeed. How are you?
Good. So we are here. This is a good time to announce early. Often, if you're used to receiving this in your feed on Tuesdays, we will move slightly and start having episodes on Wednesdays. It's a few hours, but don't worry. This is corresponding. The good news is you often hear us say things, especially in 2020, I feel, more so than any other year. You hear us talk about stuff, and you probably are going, I don't know why they said that. 9 stories already happened since then. Because obviously we would record the week before and then release it early in the week. We're going to move to recording a tighter window of recording closer to when we release. That does require us to move to Wednesdays, but I think it'll
help.
It'll be for the better for all the rest of you to feel long term, like, when we talk about stuff, not knowing that it didn't happen.
What's going to happen in the week in between recording and releasing.
Right. And obviously this year has been the most troubling.
So what has happened in the legal world since last we spoke, Joseph?
Since last we talked, the Supreme Court confirmation happened, which we knew was going to happen, but that has officially happened. A second little public event was held for it, which...
So that's true. Amy Coney Barrett has been officially sworn in as a justice on the Supreme Court. She's taking over not only Ruth Bader Ginsburg's seat, but her chambers as well. So that's all real. And I know a lot of people obviously were very upset about it. But for my own mental health, I guess I'd already kind of assumed it was happening.
Of course.
It's the first time since the Reconstruction era that a Supreme Court candidate was confirmed with 0 votes from the opposing party.
Yeah.
That's
where we are.
That's a very distinct legacy.
Yeah, I feel it is. On the other hand, there is something to be said for this is also an era where we don't have, where we've blown up the concept of the filibuster entirely. Mm-hmm. So there are people who went through that process over those years who probably could have been confirmed if we lived in a world without the filibuster, but that was a tradition of the Senate that was there. Some people call it anti-democratic, which it kind of is, except it's really the only thing making the Senate close to democratic, because
the Senate is fundamentally undemocratic.
Since it's fundamentally undemocratic, the filibuster by
Rhode
design,
Island has the same number of senators as Texas.
Right. And the filibuster by design is supposed to be there so you don't get a situation where senators who are elected with 13 to 20 million fewer voters who they represent being the majority, while the people with all the actual people in the world being the minority and not able to do anything. And the filibuster is supposed to give that minority represented party some ability to slow things down. Right. It got abused pretty badly. It has then gotten blown up, and so we get to this point.
Now it's worse.
Right. And so now...
Good news, now it's worse.
Now matters are worse.
And I think that kind of is a weird dovetail into what's going on now, right? Because with Amy Coney Barrett on the Supreme Court, the one thing that everybody kind of left of center, or even a large chunk of the center, is talking about is court reform.
Yes. Well,
and I know you've said on the podcast, you've written about it extensively, but you are very concerned that expanding the court will blow up in Democrats' face.
Yeah. I'm not a huge fan of the idea of expansion. I think that part of it is and not to get all legal philosophy, is I have a very Rawlsian view of how things should work in this world.
Okay.
And I feel...
do go on.
I feel as though a lot of the problem in this world is that the reaction to the abuse that happened here with and I also am one of those people who believes there's only one abuse of the process here. It just happened in two distinct halves. Either Gorsuch gets on the court and she doesn't, or Garland gets on the court and she does. But I feel like the Republicans were going to get this 5-4 level majority one way or the other. It was the attempt to get cake and eaten it too that is an abuse. And something probably needs to be done about that to make it more fair and more representative of how the founders set up the country. That said, I would much rather not engage in the tit for tat game of, well, we'll do this.
We're going to add 6 senators.
We'll add more people, because I just feel like that only invites the retaliatory response of, well, then we're going to do it. And then that sort of, and one thing I said to somebody recently talking about this and why I would personally prefer a staggered term limit system where justices remain justices for life, but their active duty, much like we have senior judges at other levels, just redefine how the Judiciary Act works. You could just statutorily redefine it that the active panel of the Supreme Court is only the 9 most recent, and say that there's 18-year terms. Every 2 years, another one gets put on. It becomes automatic. It becomes clockwork. Who you vote for in an election becomes the person who chooses the next 2 justices, and that's it. I think that part of the reason I think that is that I was having a conversation with somebody the other day, and I said, look, tit for tat is an easier sell than putting toothpaste back in a bottle. And I feel as though if this sort of a term limit system were to come into place, and we would have at least 2, potentially 4 justices added and taken off through this format, it would be difficult then for somebody to come into power again and go, you know what, let's get rid of all them and go back to a lifetime thing where we can pack and blah. And it's like, no, it would become a norm that makes sense, that is fair, and that you could trust either direction. I like that better than whoever happens to control everything, especially where elections are screwy at this point. Representation is messed up, gerrymandering, the Senate is anti-democratic. I would much prefer a system like that than one that gives whoever has their hand on the lever the ability to blow everything up.
Sure. And it is going to be assuming, knock on everything that we have, that there is a Democrat in charge of the executive branch. Hopefully we also get the Senate. I think that it will be a very interesting world that we're going to have. I think there's a lot of proposals that are very serious court reform. And I know last week we talked a lot about Biden saying that he wanted a bipartisan commission to study it. But I think that particularly now, I think that something has to be done. I think Biden knows something has to be done. I don't know exactly what that'll be, but it'll be very, as a spectator of history as it's happening, like, this is it, right? Something will happen, whether it's term limits, whether it's expanding the court. There's also conversations about adding states, adding Puerto Rico, adding D.C. as a state. Also conversations about changing the cap on the number of members of the House of Representatives.
That is,
which are all kind of, this is a real time where reform is getting very seriously talked about and very seriously considered. And I don't remember that being as real before.
That's absolutely true. And I feel there's a piece that I will have put up by the time this publishes.
So mark this. I can guarantee this. I'll put this on the
basically,
schedule.
John Roberts faces a situation as far as the court specifically goes. I would like to think, and obviously others are going to try and get around this, but he faces a situation where the court's going to change, and they can either do this the easy way or the hard way, basically. I think that the easy way, my dream would be in this kind of neo-Rawlsian vision that I have, is that there would be a term limits law passed. The next administration would put up a justice, and that person would show up at the Supreme Court and start measuring drapes in Clarence Thomas's office, because that would be the person who would be off, through that system. If there is a challenge to it and some argument that that's not constitutional, that would get resolved pretty quickly, because one or the other of them is a Supreme Court justice, and that has to get resolved fast. And basically, if it's resolved in the favor of the term limits law, we would then have at least two.
And there's also potential stripping of jurisdiction, which you
could jurisdiction strip on that to prevent the court from making any judgment on it, which is constitutional. It's explicitly in the Constitution, but people are still afraid that even though it's written clearly in the Constitution, that the Supreme Court might decline to pay attention to that. But either way, that gets resolved one way or the other. And if it gets resolved in favor of the law, you would have a couple of people in, a precedent gets set of this is how it works, people do whatever, and then, and that's it. And if it gets struck down, if they don't want to play that game, then the response is, well, you had your chance.
Here's 20 new justices.
We know that adding 4 to 6 to, obviously, Ellie says 20, which would turn our court into like the Swiss Supreme Court, which is a joke. But nobody seriously would want that many, but I know he's saying that. But you would add people, and that would be the hard way.
Yeah.
I certainly would hope cooler heads would prevail, and we would get something that is more fair and reflects. Just democracy should not be run by an aristocracy sitting on a bench for 30 years. Like there should be some turnover. And clearly, that's what the framers intended. The first Chief Justice.
No one thought that the entire fate of our rights would turn on how long an 87-year-old is able to live.
The first Chief Justice quit before hearing a case because that's how bad this job was and nobody cared about it. Like that's what the founders thought this was going to be. And the idea that it has changed demands some sort of change with it, I think. And the Supreme Court's important. They do lots of things. They deal with constitutional law, but there's criminal law cases and there's everything, property. And,
are you building to something here? I think you're building to something.
And if you work with contracts and don't use contract tools, you're missing a lot. Save time, effort, and be more accurate with technology that reviews hundreds of pages, sorts and organizes, and helps you fix common errors in seconds, not hours. Why agonize about paperwork when you should be focusing on the deal? Don't fall behind. Visit papersoftware.com, enter the code LTN2020 to get 1 month free. That's papersoftware.com and LTN2020.
So, the other kind of issue that we're talking about with relationship to the Supreme Court, because again, it's a pretty big deal in legal circles. There is kind of the mom aspect of putting Amy Coney Barrett on the Supreme Court. People are talking a lot about the ways.
Yeah, I caught that. That was good.
I didn't even mean it that time.
Yeah. The nickname's just too perfect.
It's too good. It's too good. But it's also an interesting juxtaposition to the very famous Ruth Bader Ginsburg quote, how many women on the Supreme Court is enough? And, she famously said, when there are 9. And listen, it was a great quote. It seemed very off the cuff when it happened. It was it's great in its own way. But the reality is, I don't think Ruth Bader Ginsburg, listen, she knew at the end of her life that Amy Coney Barrett was likely to replace her years before.
This has been a known.
This has been a known fact, and yet her dying wish was still, please let the next administration replace my seat. So she didn't mean it in kind of this literal, like literally having ovaries is somehow superior to having testicles, right? She wasn't talking about it, I don't think, in quite that same way.
Yeah, definitely not. I've always thought that the way in which she was talking about it was not that 9 women is the ideal as much as it's enough when nobody would blink an eye if it happened to be 9 women.
I think that is definitely true. And obviously, physicality is not determining of someone's gender and whether someone is a woman or not. But
I think that's part of the same thing.
Yes, I agree.
It's that the norm should be that it never is notable.
It wouldn't be a problem.
It would not be notable if it were to happen.
Right.
I think that was what she was trying to say.
I think that is true, and I think that with the ascension of ACB, I think it really kind of pulls it into stark relief. And I think you also had a story this week about someone sort of defending Brett Kavanaugh. He notably has a lot of female clerks. And something that I wrote a couple years ago, gosh, it feels like 1 million years ago, but a while ago, was that I don't care how many female clerks he has. I care about what his policies do to women, and it's not good. And it's only getting worse. And I don't think that that's okay.
Yeah, no, that's definitely true. Speaking of his clerks, I guess, they had a bit of a research problem this week. Yeah. And maybe given this research problem, which we're going to talk about, maybe they needed to, I don't know, just get better at research. Because if they're looking for a true alternative to LexisNexis or Westlaw, they could save thousands this year if they switch to Casetext. Over 7,000 law firms, from solos to 40% of the AmLaw 100, use Casetext for legal research. Above the Law podcast listeners can go to http://abovthelawpodcast to try Casetext for free for 2 weeks. For $65 per month, you'll get access to 50 state and federal case law, statutes, and more with zero out-of-plan fees. Free for 2 weeks at casetext.com/abovlawpodcast.
Yeah, so it was a recent decision. Came out on Monday, I believe, the same day that ACB was elevated to the court.
Mm-hmm.
And it was the DNC versus Wisconsin State Legislature case. And in a 5-3 majority, all the conservative justices found that any extensions to Wisconsin's voter laws were inappropriate.
Yeah, the function of the decision was to not allow a stay, basically, of this to So
that you has to be received.
The weird posture, which is why there wasn't really an opinion. There were a bunch of little concurrences and dissents.
Mm-hmm. Yes, and Kavanaugh's concurrence was extraordinary. Mark Joseph Stern at Slate has an entire article that is just dedicated to all of the factual errors in the opinion. He pointed out as an example of a state, said that this should be a state-by-state decision. Some states have made no changes to their normal election laws as a result of COVID-19 and uses Vermont as an example.
Specifically Vermont, which has.
Right.
Yeah.
I mean, literally, that was last week. It was a trivia question of the day that I posed. Vermont had their Secretary of State came out and said that is just not true. They actually, what they did was mail every registered voter a mail-in ballot on October 1st. So there was extra time for people to do it, and no one had to request it, so that it kind of eliminates half the process. And that was the reason why they said that they are doing it by a receive-by date, not a postmark date, because they had already mailed them out on October 1st. And using that kind of as an example to stifle votes is wildly inappropriate and shockingly inaccurate.
I noticed when I first saw it, the one thing that stuck out to me was this quote from Professor Rick Pildes getting quoted saying that, there's a problem with late ballots, which struck me as odd, as I know Rick Pildes, and I do not think he would say that. So I went back, and sure enough, he does not say that. The literal quote says that, but
there's a straw person
it's functionally a straw argument. Or more accurately, it's a reason that you would do something different.
Right.
But this is like citing red flag cases level of bad. And you wonder why there was no clerk who was capable of finding these things. I saw a lot of the mistakes clarified by Tierney Sneed from TPM, actually who Mark Joseph Stern in that article, he credits as where he first saw these too, because I think she was the first person to sit down with it and really dig into, wait a minute, these are all mistakes. But it's true. This is what a clerk is theoretically there to do. And especially because none of these citations really were necessary. I mean, some of the factual errors that when MJS expands on this, he talks about some certain things that are just wrong.
Right.
But partisanly wrong. Like it's wrong and you're saying it for a reason. But a lot of these others are just errors that are being made gratuitously. You don't need to add to the pin site with a case that actually concludes the other way. You don't need to add to Vermont as an example when it's not true. And this is stuff that anybody who's remotely good at this job would have noticed and pointed out. And it really underscores something that we've been talking about a lot. And I know that there are some firms out there that a lot of money. That a lot of them are quiet about it, but the clerks in this world who get all this money because they're the cream of the crop, supposedly, the way in which conservative judges and justices have been aggressively hiring within this kind of echo chamber of FedSoc treasurer at whatever, you get this clerkship, and not necessarily the people who are the cream of the crop anymore. And this sort of churn has resulted in a situation where it's devalued some of these clerkships. And you get situations like this where people are making sloppy, bad mistakes that, frankly, summer associates don't make.
Or shouldn't.
Honestly, the one of them, I was just like, I don't remember a summer doing that. And you look at these sorts of mistakes and you think this is supposed to be a clerk who's supposed to get all this money and bring prestige to the firm. And that's why some firms, again, they're not talking about it a lot, but they scrutinize clerkships that they didn't used to. They used to say, ooh, 2 federal clerkships, you're in.
Dun,
and now
dun,
they
dun.
look.
Now it's like, wait, who did you clerk for?
Oh,
Well, I mean,
yeah.
For the first time, we have a spate of federal judges that were ranked unqualified, right?
Yeah.
And so if you're clerking for them, it's not going to have the same weight as someone who is ranked qualified.
Yeah. I mean, if there's a logic to clerkships beyond a reflection of your transcript, which in theory your transcript is your transcript, so you don't need that.
Right.
But if there's any logic to it, it's that you learned some invaluable information learning at the knee of some grand practitioner. And when those grand practitioners are rated not qualified, it's difficult to make the case that you've accomplished anything.
For sure.
Yeah,
For sure.
no, and it's sad because the whole clerkship universe is a big deal. It's one of those things that it's my biggest regret never doing, but I could not afford to not do it. I came out in a year that was one of those great salary bump years, like one of the big jump ups, and the clerkships did not increase.
Respond. They don't listen to Cravath, unlike
and clerkship bonuses back then were $10,000. Like it was, you come in as a second year as opposed to a first year, and here's $10,000. And I just looked, it was like, so I'm giving up like $70,000 to get 10, and I was just like, I can't do that. And it's really sad because I think I would have really enjoyed that. It was my kind of stuff, like bookworming was kind of my thing. So yeah, it's sad, and that this has been trashed like this. But
yeah, I mean,
alas.
One of the other kind of things that struck me about the Kavanaugh decision is that for an originalist, someone who cares so very much about what happened in the 1700s as it relates to constitutional law, puts a really strong value on knowing on election night the winner of the election. That is an incredibly modern
as the founders would have had it. Instantaneous, electronically transmitted results, obviously, as of the end of election day,
as of midnight.
Yeah. Well, I mean, the founders wouldn't have even cared about that. The founders didn't even contemplate the idea that you would get to vote. The founders technically just said state legislatures get to decide who the electors are. The idea of the state holding citizens voting to decide who the electors are isn't even a concept that is clear from the Constitution.
Right. It strikes me as a thoroughly modern problem, and as a touted originalist to kind of say, well, we need to know right now. I mean, it's nakedly partisan.
We have a mailbox rule in this world.
Yeah.
We have a rule in contracts that is about the idea that we all understand that once you put it in the mailbox, it's done and it counts as of that moment. And it's just really...
I mean, it only makes sense if you assume that he wants a particular result.
But I mean, this goes back to your point. This is where, unfortunately, I think we've pushed to reform now being a necessity. Yeah. It's no longer... It's now just a question of what form it takes.
Yep. There's not a question of if, it's what.
Yeah, and
that's exciting.
It's interesting.
It is interesting. I think it'll make for... hopefully the next 4 years to be very interesting and very thought-provoking as we try to figure out what do we do in a post-Trump world.
Yeah, figuring out how to come out of things. How have law firms weathered previous economic downturns and come out stronger on the other side? LexisNexis Interaction has released an in-depth global research report confronting the 2020 downturn, lessons learned during previous economic crises. Download your free copy at interaction.com/likealawyer to see tips, strategies, plans, and statistics from leaders who have been through this before and how they've reached success again. So, finally, I guess there's a story that kind of a fun evergreen story to discuss. Mm-hmm. What would you do if you've been,
all I can think of that City High song? What would you do? Do you remember that?
You've been right. Okay, so you've been accused of several crimes over the years.
Ooh, okay.
You're facing charges for this. You've got a guardianship thing going on with one of your kids. It's just like the legal issues are just piling up, and you know what? It's tough. Like when you're in that sort of situation, and it's a true testament to the access to justice problems in this country.
Sure.
You may not be able to find yourself a lawyer.
Right. And pro bono lawyers are fewer and far between, particularly, during this time. It's pretty tough out there.
So allegedly, New Hampshire resident Lisa Landon allegedly found a solution for this.
Was it creative? Was she thinking outside the box?
She was thinking outside the box.
Okay. Points for that.
I was impressed.
Creativity.
Yeah. She went to the court and said, yeah, I'm the prosecutor. I'm dropping the charges against this woman.
I'm guessing she's not actually the prosecutor.
No. The defendant is not, in fact, the prosecutor.
Yeah.
But no, utilizing the electronic system, among other things, managed to pretend to be, allegedly, the prosecutor to get all the charges dropped. Also pretended to be a retired judge and filed an opinion, supposedly by him, to waive filing fees and a different thing that she was doing.
Oh, my God.
Yeah. She is facing a charge of false impersonation and 6 charges of falsifying physical evidence.
Well, that seems like allegedly what she did.
Yeah. You know,
Listen, she thought outside the box. It's a trying time.
I feel like we're coming up on the end of the year, which means we're coming up on the Above the Law Lawyer of the Year nominees. I feel like
not eligible since she's not a lawyer.
I don't know. Like,
I'm going to hold the line on this one. You have to actually be a lawyer to count as Lawyer of the Year.
I mean, you don't have to be licensed. I don't think we have to say people are licensed. We just they have to be. I mean, lawyer's more a state of mind, as far as I can tell.
If you believe you're a lawyer, you are a lawyer.
Yeah. Look, I mean, if Kim Kardashian can do it, I feel
she
like,
hasn't yet, and she's studying, and she's going to have to take the bar exam before she can be called a lawyer.
Yeah. Well, I don't know.
I'm going to hold the line on this one. I'm going to say no to be a nominee for Lawyer of the Year.
See, again, this is the kind of stinginess that I have to deal with among the Above the Law staff. This is why
you are noted generosity. No, I mean, the opposite of accurate.
I am the softie who is known for being warm and caring. For always, yeah. Yeah,
it's kind of the opposite.
Anyway. Well, I feel as though we have droned on for you all long enough. You're hearing this probably in the aftermath of Election Day, so hopefully you voted. Hopefully you were allowed to, and hopefully we still have voting in this country, which I'm not positive we will, based on this week. But who knows? Things have turned around rather quickly, so I should have, I guess, thrown in the possibility that the franchise has been totally lost. Anyway, with all that said, we will rejoin you in the future. You should be listening to this through your podcast subscription services. That's very useful because then you can get them every time they come down. You should give reviews, write something, helps more people discover the show. You should be reading Above the Law. As always, follow I'm at Joseph Patrice. She's at Catherine1, the numeral 1 on Twitter. You should listen to The Jabot, Catherine's show, and you should check out the Legal Tech Reporter Roundup weekly thing. It doesn't have like a clever name, I don't think. Anyway, but you check out that.
You don't know the name of the show you're on.
I mean, it's not. It doesn't like roll off the tongue. No, I should. Yeah, we should figure that out. Yeah.
Yeah. Noted softie, Joe Patrice.
Yeah. I don't think that has anything to do with softiness. Anyway,
it doesn't not have to do with it.
Then, with all that said, you should be listening to the other shows of the Legal Talk Network. And thank you, as always, to Contract Tools by Paper Software. And I think with all of that, we will be back soon. And then soon coming to you on Wednesdays.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. You can also find us at AboveTheLaw.com, ATLRedline.com, iTunes, RSS, Twitter, and Facebook. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.